All right, good afternoon, everyone. In the interest of time, we'll go ahead and get started. I see people are still joining, but we do have a limited amount of time. So welcome everyone to the Department of Correction Insider Series webinar. We're very glad that you could join us today for the third and final installment of a three-part series on navigating probation and parole. Today's topic is ending or completing probation. My name is Heather Doncaster, and I am the Chief of Planning, Research, and Reentry. I'll be the moderator for today's session. Planning, Research, and Reentry is a specialized unit in the Office of the Commissioner that oversees and coordinates prisoner reentry initiatives, leads the department's data collection and analysis efforts, facilitates strategic planning, oversees accreditation and compliance, and provides project and grant management for multi-bureau initiatives. Today's presenters are Probation and Parole Director Melissa Kearney and Probation and Parole Regional Manager Marcus Thompson. Melissa Kearney, Director Kearney joined the department as a probation and parole officer in 1995. She was promoted to probation and parole supervisor in 2001 and specialized in domestic violence and pretrial supervision. Director Kearney established the Victim Services Program for probation and parole in Newcastle County in 2001, a program that now operates statewide. In 2020, at the start of the COVID-19 pandemic, Director Kearney was promoted to Regional Manager of the Cherry Lane Probation and Parole Office, the department's largest PNP office, and was then promoted to statewide Probation and Parole Director in 2021. Missy is a member of the department's Critical Incident Stress Management Team and serves as the Deputy Compact Administrator for the Interstate Commission for Adult Offender Supervision for the state of Delaware. Director Kearney has a BS in Community and Family Services from the University of Delaware. Marcus Thompson began his DOC career as a probation and parole officer in 2000. Manager Thompson has supervised a variety of caseload types and participated in various pilot programs. Manager Thompson has supervised standard probation caseloads, reentry court, enhanced supervision, and CREST aftercare. In 2011, Marcus was promoted to probation and parole supervisor of the Level 1 Administrative and Absconder Unit at the Cherry Lane Probation Office, where he took on additional responsibilities, including the intern program coordinator. He was an OJT presenter for the district office, a member of the facilities committee, and a liaison for Gateway, FedCap, and the Delaware Center for Justice. In 2021, Manager Thompson was promoted to the regional manager of the Cherry Lane Probation Office. During his tenure as manager, he has overseen as many as 12 community supervision units composed of over 120 staff members. A lifelong Newcastle County resident, Manager Thompson is a proponent of building strong ties in the community. In this regard, the Cherry Lane Probation Office held its first community resource event in the fall of 2021, less than 6 months into Manager Thompson's capacity in that role. Those annual events have continued and have proven very successful. To date, with the help of community partners, over 650 community members have received services ranging from clothing, food, healthcare, and treatment referrals, just to name a few. Manager Thompson and staff are steadfastly committed to positively impacting the lives of the citizens of the state of Delaware. So thank you very much, Director Kearney and Manager Thompson, for joining us today. Today's agenda will include a recap from last time on the use of graduated sanctions and incentives, information on the conditions of supervision, the probation violation process, as well as ending supervision. We'll also give some information about ways to get involved and connected. And at the end, we'll have a period for Q&A. We do ask that you submit any questions that you have in the Q&A box on your screen versus in the chat. It's just easier for us to keep track of them and respond that way. Please keep in mind that we aren't able to answer questions about specific individuals, either in custody or under supervision. If you have questions about specific individuals, we will give you information about how to reach out and get information on specific people. And also likely won't be able to get to all questions answered or asked. I'm sorry. So we will follow up for any questions that we aren't able to answer during the webinar, as long as your question is asked. As long as you don't ask your question anonymously, we will be able to follow up with you after the fact. So if you ask your question using your name in the Q&A box, we'll be able to follow up if we don't answer during the webinar. The webinar is recorded and posted to the department's YouTube channel. You'll also find all of our previous webinars on the department's YouTube channel. We will make the PowerPoint available after the webinar, and we will supply certificates of attendance for those who stay tuned for the entire webinar afterwards. We also will conduct some polls during the webinar to kind of keep things interactive and interesting. And for our first poll question, we'd just like to get an idea of who's joining us today. So I am going to launch our first poll as a check-in. You should be seeing it on your screen now to get a sense of who's joining us. So if you want to weigh in, all poll questions are anonymous. So if you want to indicate what stakeholder group might best describe you, DOC employee, state agency employee, member of a nonprofit organization, community members or advocates, students. I think you have to scroll down, there are more options. For-profit human services company, a member of the legal community, the media, legislators, others. So I'll just give people another couple of seconds to weigh in. Let us know who's joining us. That would be great. All right, and I'll go ahead and close out the poll. Anyone wants to weigh in at the last second? All right. So it looks like we have a lot of DOC staff with us today, as well as other state agency employees, members of nonprofit organizations, and some community members. So that's great. So we really appreciate, oh, look, and some members, scroll down, from the legal community. So we really appreciate everyone joining us and taking the time out to learn more about the department. So let's see, next slide. What you see here is just kind of the, well, it's not kind of, it is the locations of the department's district offices throughout the state. We have 2 offices in Newcastle County, 1 office in Kent County, and 2 offices in Sussex County. You can find more information about the offices throughout the state on the department's website at doc.delaware.gov. And now I will turn it over to Manager Thompson to get us started. All right, Marcus.
Good afternoon. Thankful to have the opportunity to be a part of this Navigating Probation and Parole series. Prior to discussing a few new areas, we thought it was important to revisit a few topics from our first two series presentations. These topics concern the methods our probation and parole officers utilize to address probationers' compliance and non-compliance while under supervision. Next slide, please. Addressing compliance. Go back one. Thank you. It's the policy of the Division of Probation and Parole that all employees will work towards the goal of promoting positive behavioral change and help people under supervision work towards the successful completion of all periods of supervision. And if I would say, this policy places an emphasis on our staff working to help people under supervision work towards the successful completion of their supervision periods. We understand that this collaborative effort where both parties work together is vital to the success not only of our department, but to the success of the probationer. Next slide. As a department, it's paramount that our officers recognize, reinforce, and at times reward the positive behaviors of our probationers. In this regard, we utilize graduated incentives to address compliance. Examples of graduated incentives are verbal recognition, reduced curfew hours, reduced contact, increased travel flexibility, earned compliance credit discharge, early discharge, modification and removal of special conditions, certificate of completion of special conditions, and others graduated incentives as approved by the supervisor. These incentives are instituted at various levels of compliance, and as such, they require different levels of oversight. For example, if a probationer comes in, to give an example, if a probationer comes in and they're having problems reporting to their treatment provider on time, yet the treatment provider gives the officer a call and states that a positive report stating that the probationer has been reporting on time, this officer may, in the next office visit, offer verbal recognition for that probationer as a graduated incentive. Later, the same probationer successfully completes that treatment program and two, perhaps has a promotion at work. This officer may, in case conference with his supervisor, make the recommendation to have the curfew requirement lifted from this probationer. If that supervisor approves, a progress report will be approved and forwarded over to the court. At that time, the sentencing authority will review the request, and in this case, approve the request, and the curfew is removed. Next slide, please. It's equally as important to, when effectively helping change behaviors of probationers, for our officers to address non-compliance while under supervision. Our department addresses non-compliance with the conditions of supervision through the use of graduated sanctions, with only a few exceptions. And those exceptions are risk to the community and/or identified victim, court orders limiting an officer's actions, such as zero tolerance conditions, or a new criminal arrest or statute. It is important to note, in regards to the zero tolerance conditions, that in 2018, former director and now current DOC Commissioner Tara Taylor put out a directive that P&P officers cannot recommend zero tolerance conditions. Next slide, please. In most occasions, non-compliant behaviors are addressed through graduated sanctions. They are such as verbal warnings, travel restrictions, the curfew increased contact, increased substance abuse or alcohol testing, job search, job training referral, community service hours, increase in treatment, increase in supervision level, work crew, a special condition addition, and or administrative commitment to level 4. Again, these graduated sanctions vary in severity, and while some can be addressed directly by the officer, such as a verbal warning, other high-level sanctions require supervisor approval, and at least on one occasion, multiple supervisor approvals when administering an administrative commitment. And I think it's important to note in this case that when these sanctions takes place, in each of these cases, they're communicated and acknowledged by the officer, but also by the probationer. In most instances, this is done, well, in all instances, it's done verbally, and more often it's done in writing. As a department, probation and parole understands that in order to effectively change behavior, there needs to be dialogue, collaboration, and commitment between both the probationer and the probation officer. Next slide, please. At the initiation of any probationary period, the conditions of supervision are reviewed and explained to the probationer. It should also be noted that probationer is also given a copy of these conditions. Next slide. On levels 1, 2, and 3, there are 9 standard conditions of supervision. They are, number 1, you must not commit a new criminal offense or motor vehicle offense during a supervision period, You must report any new arrest, conviction, or police contact within 72 hours. You must report to your supervising officer at such times and places as directed, and permit the probation officer to enter your home or visit your places of employment. You must have authorization from your supervising officer to leave the state of Delaware or your approved state of residence. You must report any changes of residence and or employment within 72 hours to your supervising officer. You must have written approval from your supervising officer to own, possess, or be in control of any firearm or deadly weapon. You are not to possess or consume a controlled substance or other dangerous drug unless prescribed lawfully. You are subject to random testing as directed by your supervising officer. You must pay a supervision fee as required by state law in accordance with a schedule as established by the Department of Correction. And you must comply with any special conditions imposed at the time of your supervising officers of the court or the Board of Parole. You'll note that there's an asterisk there that discusses supervision fees. As a department, understanding the pending legislation going forth, deciding whether it was necessary or needed to have supervision fees. As a department, we no longer actually require the collection or the imposition of supervision fees as a practice. Next slide, please. So most often people have questions surrounding the special conditions and what their purpose are. Special conditions are approved or imposed by the sentencing authority to address criminogenic risks and needs. These needs are risks such as treatment regarding sex offender treatment, substance abuse disorders, mental health disorders, domestic violence treatment, anger management treatment, parenting classes, DUI classes. There also can be special conditions that contain no contact orders. They may be with a victim, a co-defendant, may be relative to an area. Also, there are other special conditions. They could be required to perform community service, obtain a GED or diploma. There could be a restitution order. There could be an order of electronic monitoring or a court-ordered zero tolerance. To the right, you see a small sample, just of a month sample of initial technical violations reports about the condition 9 citations. I will add, and I know Director Kearney will go into this further, but almost all occasions, these are also, their technical violations are done in tandem with each other. There's rarely, because we utilize graduated sanctions, there are very few rare occurrences, except when we have to, as we talked about earlier, where there will be just one technical violation. Next slide, please. As level 3 is our most intensive level of community supervision, it has 4 additional conditions of supervision. They are: you must not quit a job, training program, or school without prior approval of your supervising officer. You must be employed full-time or active in job training or school on a full-time basis. If not, you must attend a job search program or perform community service on a schedule established by your supervising officer. You must participate in 0 to 35 hours of community service each week as directed by your supervising officer. And lastly, you must abide by a curfew established by your supervising officer. I know, and Director Kearney will get into this, the most widely mentioned condition, especially out in the community, is the curfew condition. Later in this presentation, you will see documentation that will indicate that this, along with other conditions, when cited in violations, are primarily cited in tandem, not specifically one occasion with other technical violations. Thank you.
All right, thank you so much, Marcus. I think we are going to turn it over now to Director Kearney, who is going to talk to us about the violation of probation process.
All right, thank you. So the reason we're here is to really debunk any myths that are out there about violations and how we do business. So here are some facts about violations. The vast majority cite multiple conditions, as Marcus said. So a lot of times there are multiple conditions cited, not just one missed office visit is leading to incarceration. It's a multitude of offenses. We're looking at behavior patterns. So it's not an isolated incident leads to a person being reincarcerated. Also, conditions 10, 11, 12, which Marcus went over, are the least cited conditions, and they are for those high-risk people. And that involves the job training, the job search, the employment. They are rarely, if ever, cited as conditions for violations to the court. Another condition number 8 is no longer enforced. We do have some people who, when the law changed, they still fall under requiring a supervision fee. So that's why it's not completely gone, but eventually through attrition, condition 8 will be obsolete. But we don't cite people for that condition. Homelessness is not a reason for a violation. So even though they are required to report a new arrest within a new residence within 72 hours, homelessness is not a reason that we cite someone. If someone is homeless, they just need to notify their officer where they're staying each night. If that changes multiple nights, they just have to be in contact with their officer to let them know. At the same time, we'd be offering services to that individual if homelessness is an issue, and try to provide resources to get housing squared away. Violations are not typically submitted for curfew violations only. A lot of times it's a new arrest that happened after curfew, and that's why the citation is for condition number 13, which is the curfew violation. Non-compliance while violations are pending will result in supplemental reports to the court. So sometimes there's a violation that is pending and they're out in the community while the violation is pending. Then new things occur and another violation is submitted before that actual hearing happens. So that's why it's sometimes difficult to count a violation as one incident, because sometimes there's multiple violation reports that are submitted while the violation is pending. And another myth is that is untrue is that people return to incarceration for violations. Usually it results in one CENTAC level increase. So if someone's on level 1, the results will be a violation recommendation for level 2, level 3, and so on. So next slide. This chart describes the 5-year trend starting in 2019 and the top 5 conditions cited. The most frequent citation, as you can see, is for condition number 1, which is incurring a new criminal arrest. So if you look at the chart, it's a little bit more than 50% of the violations we submitted are due to new arrests that are incurred while they're on probation. The second most frequent is the condition number 9 in the special conditions. And I have to state this in something that Marcus brought up. It's mostly because they haven't completed their treatment program. So many times, for whatever reason, there is a delay in people engaging in treatment, but the program needs to be completed within that term. So if the person has not completed a treatment program, but say, for example, is engaged, we will have to write a violation and explain to the court why there was a delay and why the person has not completed the treatment program within that time frame. We can't just extend somebody's probation period. We have to then notify the court they violated that condition to ask for usually a continuance of that term until that program is done. Another common citation is condition number 3, which is reporting. The condition number 3 usually goes along with someone absconding from supervision. So we don't know where they're staying. They stop reporting, and we're asking for a caveus. Condition number 7 is for drug use, and condition number 13, as you can see, it's one of the top 5s, but it's less than 10% of the people that we cite for violating a curfew. Next slide.
I think we're going to jump in and launch a poll real quick before we move on to the next slide. So let's see, before we kind of move on to talk a little bit more about probation violations, let's ask a question to see what people think. So question I have here is a true or false question. I think people can see it hopefully right now. True or false? All probation violations require an individual to be arrested and held in a secured facility pending a court hearing. Is that true or false? Again, your answers are anonymous, so please feel free to answer. I'll give people a few seconds and then we'll share the results. Thank you so much for your participation. And I will close out the poll in 3, 2, 1. All right. So again, the question was true or false? All probation violations require the individual to be arrested and held in a secure facility pending a court hearing. And it looks like 95% of our respondents believe that to be false, that you are not required to be arrested and held in a secure facility pending the court hearing. Director Kearney, are our respondents correct?
Yes, they are.
Fantastic. All right. Tell us a little bit more about the process.
All right, so this slide shows you the process flow. So a person under supervision violates one or more conditions of supervision. For example, someone tests positive for cocaine, which is a violation of condition number 7. And say, for example, the court never imposed a substance abuse evaluation, but in the course of supervision, we determined that this person has a substance abuse problem. We will impose a graduated sanction at that point and probably do a verbal warning and write to the court a progress report imposing a special condition for a substance abuse evaluation and treatment. Say, for example, that person continues to use drugs and fails to report for their treatment program. A determination could be made, maybe we will do an administrative commitment, which is a weekend at a level 4 facility or on home confinement to address the behavior. The other option is we can submit a violation to the court right at that point. We can do an administrative warrant if we choose to, if the person poses a risk to themselves or others. Say the example I use with cocaine, it's the use of heroin and the person has overdosed multiple times and we're concerned for their safety. We may choose to do an administrative warrant at that time, which means we take them into custody immediately, bring them to the court, bail is set, and a hearing is set for that violation. So the administrative warrant doesn't require approval from the court. So it's done before the court process, but then the violation hearing is scheduled and the violation then report is forwarded to the court. If for example, the person using cocaine is coming in, but they're still using, they are going to treatment, but it's sporadic, we may do a summons to the court for a violation of probation, meaning they stay on the street while a violation is pending. And once the court scheduled the hearing, both parties attend the hearing and address the violation. If that person, say, stops reporting and is moved and we don't know where they are, we can ask for a capias. And generally that's what happens when we ask for a capias. We get the court's approval for a capias. It's entered in the system by the court. And then if they're picked up or if the probation officer picks the person up, then the violation is scheduled and held. I want to point out that once the hearing is scheduled, it is the sentencing authority that makes the determination as to if they violated the probation and what the sanctions are. So I just wanted to point that out. Next slide. This is a cover page example of a violation report. It includes the sentencing information, the underlying sentencing information, how the person violated the conditions. It will say if we impose graduated sanctions, what internal sanctions we did. So we're trying to correct the behavior before we write to the court. So those graduated sanctions are listed on the violation reports and are then not cited in the conditions of supervision that we cite when we report to the judge. So we're letting them know we've done this, this, and this, and their behavior has not changed, and therefore we are submitting this to the court, letting them know how they violated the court order. So probation is an alternative to incarceration. So when they are sentenced to a period of level 5 or jail time, and that's suspended for a probation term that is determined by the court. We also, which is not shown on the slide, but the content of the violation includes Exhibit B, which are the facts of each citation for the violation and how they violated. It also includes a history of supervision, which is basically the narrative of what they did while they were on probation, and the narrative is going to justify what the probation officer recommends. So again, the officer will recommend if they're summoned to court, if a violation request for a capias is asked for, or if they did an administrative warrant and a hearing is already scheduled by the court. So we will ask for a service request and we will make a recommendation for sentencing. We make a recommendation, again, we don't determine the outcome. Next slide. So once we get to the violation court hearing, these are the stakeholders that are present. So the probationer is present, the probation officer, the legal representation, either a public defender or a private attorney, and the judge is there. And what happens is the probation officer will present their violation. So they will state the facts as to how the person violated the probation. They will, and that's standard conditions, special conditions. They will then articulate, highlights of the history of supervision and make a recommendation to the court. Sometimes the judges in the defense might have questions that are brought up during the hearing process. Again, the recommendation is generally to move up one CENTAC level. So if they're on level 2, the recommendation may be level 3. If they're on level 3, the recommendation might be level 4, unless there are aggravating factors. If there are aggravating factors that involved community safety, public safety, a risk to victim, repetitive behavior, weapons involved, willful failure to comply with treatment, we might ask that the person move more than one level. At this point, if a person's on level 3, we might ask for level 5. Say, for example, they incurred new arrests and it's a domestic situation and they violated no contact orders and maybe there was a weapon involved. We might ask for jail time in those kind of circumstances. So then the probationer has a chance to address the judge, and usually they will either admit to the violation or refute some of the allegations, and there's discussions that happen during that process. The attorneys usually, sometimes they speak, sometimes they don't, and then the judge renders a decision as to which conditions they violated and what the sanction will be. Next slide.
Okay, I think we are moving on to ending supervision, and we are going to launch another poll here. So let's see. Our next poll question is related to term limits for probation. So the question is, per Delaware code, the maximum length of any period of probation or suspension of sentence is limited to how long? 1 year, 2 years, 5 years, or 10 years? If people would like to take a guess. Again, your answers are anonymous. Appreciate the participation. Give people a few more seconds to answer. So again, per Delaware code, the maximum length of any period of probation or suspension of sentence is limited to how long? All right. We'll close it out in 3, 2, 1. For any last minute voters. Okay, so we have, let's see, a majority of our respondents believe that the maximum length of a period of probation is 2 years, followed very closely by 10 years. And I will let everyone know that the correct answer is B, 2 years. So individuals convicted of violent felonies may be sentenced to a probation term of up to 2 years. And Missy is going to tell us some more about probation term limits.
So in Delaware, the term limits are decided by statute. So Delaware Code Title 11, Section 4333, we call it Senate Bill 50 when it passed in 2003. It limited probation terms. So it's 2 years for violent offenders, for any violent felonies, 18 months for Title 16 or drug offenses, and 1 year for most every term. The other thing that this statute did is it made probation terms happen at the same time. So they run concurrently rather than consecutively. So for example, if someone is charged with and sentenced to 3 counts of burglary, and there's a 1 year jail sentence on each term, but the probation term will only be 1 year. So all 3 years are served at the same time for each count of burglary. Delaware is progressive. We are part of our interstate compact where we get cases from other states, and Delaware's probation sentences are way shorter than our surrounding states already with when this law passed back in 2003. So we have incoming cases that we supervise for other states where it's a misdemeanor offense and it's a 5-year sentence for probation. So we are progressive in our term limits right now when that bill passed in 2003. Next slide. Once a person reaches their maximum expiration date or MED, we will write to the judge and explain if they've been compliant with their probation term, and we will ask the court to discharge their probation at their maximum expiration date. If they have complied early in and they've done everything they're required to do, including paying all their costs and fines, we may write to the court and ask for early discharge, and that's upon court approval. Also, the court can order a discharge at any point during the supervision period, so that's up to the discretion of the court. We also have earned compliance credits, which a person gets good time credit while they're on probation, and it's 30 days credit for every 30 days they serve, up to 6 months or up to half of their term, and generally it's a 1 year term, so it's 6 months. So that happens without the court's approval. If they are doing everything that they're supposed to do, our system will notify the officer that this person might be eligible for earned compliance credit, and we can close them out immediately and then notify the court that we've closed out this person's case because they've done everything that's required of them, and it's pretty automatic. So next slide. I want to give everybody time to read these because these are 3 recent emails that have come to me as the director from former probationers and from a program director who we work with in the DV community in Kent and Sussex. It just shows the collaboration and our willingness to help people that I think sometimes, again, a myth that's out there is that we're just out to arrest people and we don't offer assistance. I mean, the community programs we're doing, a lot of the in-house services we have at each of our facilities, we collaborate with so many other programs to make a person succeed in the community and to change their behavior. So, I mean, I'm not going to read them to you, but I think they're pretty impactful. So this all ties to our commitment for success. And it ties everything together from the three series we did about probation and parole. We do evidence-based practices. We try to meet the behavior of the risk behavior to the supervision level. We attempt to identify needs to enforce programming that individuals might need. We collaborate with all of the stakeholders in the system and provide support, resources, services in an effort to rehabilitate. So that is our goal. We have in-house programming, like I said. We have a contract with Brandywine Counseling, who provides in-service substance abuse evaluations and treatment. We have Delaware Center for Justice that's in-house that provides case management and job training. We're collaborating with the Department of Education. We have net counseling mobile buses that come here that offer treatment in our parking lots. We have sex offender and domestic violence groups in-house. So we work to have it be a one-stop shop for those who have to report to also get services. We also, not everyone who is on probation has served time in a facility. Sometimes people are sentenced directly from court, but for those who do a period of incarceration, we do have in-reach services where we go into the facilities and we provide supportive services prior to release. And this was discussed in one of the prior series, but we go in and we provide some services to people so that when they come out, they have credential cards, they have the information they need to get started with their lives. So as you can see, that's shown from our mission statement. Our mission statement has just been updated. It's our DOC mission that we protect the public and promote successful reentry through safe and secure facilities, effective supervision and rehabilitative services, supported by a professional and diverse workforce. So thank you.
All right, thank you so much, Missy and Marcus. That ends kind of the providing you information portion of the webinar, and we'll move on now. We have about 10 minutes left to kind of the Q&A portion. I just wanted to provide you a little more information before we close out. So we do have up on the screen some email addresses for the different teams at the DOC who might be able to help you with any additional questions that you might have. For questions about specific people who are under supervision or in custody, you can contact the community relations team and they can assist you or refer you. Just keep in mind that we cannot release certain personal or health related information on individuals without their permission. So if you are asking about a specific individual, the team may inquire about your relationship with the person to ensure the proper releases are on file. We've also included our victim services, contact information, as well as our DOC reentry team mailbox. If you have questions or concerns. We also, if you are interested in becoming more involved with the department, we have another hiring event this weekend on June 1st from 8 a.m. to 1 p.m. at the Department of Correction Administration building here in Dover at 245 McKee Road. Walk-ins are welcome, but applicants are strongly encouraged to apply in advance. And you can find all of our hiring information at joindelawaredoc.com. And next topic for the DOC's Insider Series is to be determined. So just keep an eye out for announcements about the next installment. Again, information is always available on the department's socials. The this webinar will be posted to our YouTube channel in the next few days. And you can view all of our previous webinars on the department's YouTube channel. I will go ahead and launch a poll, the last poll, just about how you feel about the information that we did provide to you today. If you would like to go ahead and rate today's webinar. Again, this is anonymous, so please feel free to respond. And then we will move on to some of the questions here. So, Missy, I think you touched on this, but just to clarify, right? There's a question about, the question is, can minor infractions that are handled through graduated sanctions later be submitted as violations? And you touched on it, but can you just answer that clearly here?
Yes. No. So if a graduated sanction is done, it is informational to the court that we've done this internal sanction, but it's not part of the evidence and the allegations in the violation. So essentially, it's just telling the court we've addressed this behavior, but it's not citing them for that, because it can't be cited in the violation once it's addressed as a graduated sanction.
Thank you. And then let's see. Are probationers given documentation of their infraction and the sanction issued in situations of graduated sanctions?
I was trying to wait for the train to come by. So it could be a verbal sanction. So it could be just verbally, this could lead to a violation. So they may or may not know it's an official graduated sanction. But if it's something significant, say, for an example, it's an administrative commitment to a level 4 facility for the weekend, they would get notice because they are instructed to report there for a weekend. So it actually depends on what the sanction is. If it's a added condition, then yes, they would have to sign documents saying, like the example I gave where substance abuse evaluation wasn't part of the original sentence, but we're imposing it as a graduated sanction and we got approval from the court, then they would sign the document adding that condition to their, and they would sign off on it.
Great, thank you. And then, are there any fees leveraged against a probationer for graduated sanctions or for VOPs?
No.
All right. And then this one, I think I'll probably answer. So, or you guys could chime in too, right? So there's a question about collaboration with employees, and I think you guys can help with this one too, right? So employers who are willing to hire people who are coming out of incarceration, and what kind of employers and in what areas of employment, right? So the department collaborates, works very closely, right, with the Department of Labor. The Department of Labor is a partner on the Delaware Correctional Reentry Commission. We do a lot of work together, and we, the Department of Labor, I think, helps us identify and helps us work with employers who are, who are more open than others to hire people with backgrounds. The Department of Labor offers different services to help incentivize employment for people post incarceration. They have, there's training available, and there are resources available for employers to mitigate any potential risks. We also, the Department of Labor undertakes research to kind of look at the, in-demand employment, these in-demand fields, and the Department of Correction uses that information to kind of guide the training that we're offering within our facilities, right? So we will look at the kind of like high in-demand jobs and use that to look at the high in-demand jobs from the Department of Labor, look at the results of the vocational surveys that we take from people who are within our facilities for their interests, and kind of use that information to guide programming and training that we might be able to make available to people. So I think there's a lot of collaboration between the Department of Correction and the Department of Labor. And then I think that helps the collaboration with employers. Sometimes I will say that, oftentimes employers don't necessarily want it advertised that they are willing to hire people with a criminal background, which, but there are people out there. There are certainly employers out there who do, and we, I think, as a department, are also cognizant of, we make sure that we don't want to be offering training or spending a lot of time or a lot of money to train people in fields that they're less likely to get employment in, right? So we're looking at making sure that there's licensing requirements that aren't going to have barriers, right? So all of those things are kind of considered when we're looking at things that are being offered or being considered within the facility. So I definitely think that there's a ton of collaboration between labor and community partners and the department.
I would say,
Yeah,
I'm sorry. I would also say that we do have our cooperating providers and neighbors. We actually have VCJ on site, and we have employment specialists, and we also have other groups that come in directly to our office who have already had those relationships built with employers who will hire people and give them a second chance and opportunity to be employed. And it's true, sometimes they don't contact us, but they do contact some of the other agencies, and we're very fortunate that these services are on site so that our probationers are able to take advantage of them weekly when they come to the office.
Yeah, we've had resource events at the district offices, like Dover just had a job BQ, like barbecue, and had multiple employers there taking applications. So we collaborate and schedule those events on a regular basis as well. And sometimes it's an employer who was in the system who is seeking out people that are coming out of the system that they want to hire, so.
All right, well, that looks like all the questions we have so far. And that's just about time. So I think we planned that out pretty well. So again, thank you, Marcus and Missy, for providing us the information. Thank you everyone for attending. You know, I can't, you know, we've done quite a few of these at this point, and I still really appreciate the attendance and people's kind of desire to learn more about the department and the things that we do. Share the information with your friends. We, you know, like I said, we have all of the previous webinars are available on the department's YouTube channel. We will send, like I said, we'll send the PowerPoint after the fact. We will, and this webinar will be available on the YouTube channel in the next couple of days. And you know, you received you can respond to the registration information that you received. I think it goes back to Tom Aiello. If you have any recommendations for kind of upcoming webinars. And, you know, again, we just appreciate everyone's interest in the work that the department is doing. And again, if anyone's interested in working for the department, we have a hiring event on June 1st. And then if you aren't interested maybe in becoming a correctional officer, we do have other positions always available, fiscal positions and all kinds of things on the state jobs website. I think, Marcus, did you want to add anything?
No, I believe this, but I want to thank everybody for taking the time out and spend a little lunchtime with us. It's hopefully you found it informative, and you know, I hope you can find that we're definitely out here, and our officers are committed to making a change, a positive change in the community and then to the lives of our probationers.
Great, thanks guys. See you next time.
Thank you.